Here are the 3 mistakes I see most often in California, even after a family has already set up an estate plan. These are the ones that create probate problems, slow everything down, and put families through stress they never expected. Mistake number 1 is that people fail to fund the living trust. People sign a beautifully drafted California revocable living trust, then leave their home, bank accounts, brokerage accounts, LLC interests, and personal property sitting in their own names. When that happens, the trust can't do its job. The home still goes through probate. Accounts get frozen. Successor trustees have no authority. Funding is the mechanical step that moves assets into the trust. Without it, the plan is a shell. The second mistake we see is that people never update beneficiary designations. Retirement accounts, life insurance, annuities, and certain financial accounts pass by beneficiary designation. If those designations point to the wrong person, an ex-spouse, a deceased individual, or no designation on file, the asset bypasses the trust entirely. This single mistake often triggers avoidable taxes, delays, and family conflict. It also blocks the coordinated distribution pattern the trust was drafted to create. The third biggest mistake we see is people failing to update the plan after life changes. Divorce, remarriage, births, deaths, new business interests, new real estate, children reaching adulthood, a beneficiary developing special needs, or the loss of a trustee or agent. These events require updates. California law also changes. Trust language that worked 15 years ago may be outdated today. When people ignore these shifts, their plan no longer matches their reality. That gap is where fights, confusion, and unintended outcomes show up.